Contracts under Scots law are normally in writing between two or more parties, but it is not uncommon for a contract to be created between parties verbally. In certain circumstances, under Scots law, it is not possible to have anything other than a written contract between the parties, for example, when buying or selling property. Ideally, all parties to any contract should sign the contract, but in certain circumstances it is possible to prove that an agreement has been reached in contract even where one or more of the parties has not signed the contract. Given all of the differing circumstances brought about by contractual agreements, we always advise our clients to consult with us before entering into any contract. Breach of any contract happens when one party to the contract does something or does not do something which could be regarded to be against at least one of the terms of the contract. If this happens to you, then you have the option to continue with the contract, but only where this remains possible, or to terminate the contract due entirely to the other party's breach. If breach happens, then the party causing the breach runs the very severe risk of becoming liable to the other party to the contract due to their breach. Our expert contract solicitors are asked about the costs of breach of contract almost every day. Without question, ultimately, if parties cannot remedy the breach to the contract or agree a resolution to the breach, then court litigation will be necessary. Because of the extreme costs of court actions, this is why we always recommend to our clients that they speak to us before entering into any contract for clear advice on the contract terms. There are many legal remedies available to parties who suffer a breach, and in certain circumstances, these can be dealt with before the agreement is even reached. The complexities of contracts and their breach is one of the many reasons why our first consultations at Complete Clarity are entirely free of charge and last until such times as our clients are entirely clear on their legal matter and the costs associated with the legal action we advise them to take. If you suffer from a breach of contract, you are entitled to reclaim all of your reasonably connected losses. Since all contracts are different, there is no clear definition where losses start and where they end. In certain circumstances, losses are very low, but in others, losses can be very high indeed. For example, someone who contracts to buy a house and then pulls out can be liable to the sellers for all sorts of losses, to include loss in resale value, legal costs, estate agency costs, and possibly so much more. Again, we recommend that everyone who suffers from a breach of contract organises their first free consultation with our specialist solicitors to gain the best legal advice possible.